before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5168, Thomas A. Montgomery and Beth W. Montgomery, appellants, versus Internal Revenue Service. Ms. Boylan for the appellants, Ms. Bringer for the appellate.
Ms. Boylan, good morning.
Good morning, Judge Henderson.
Proceed, please.
Thank you, and may it please the court. This case is about the Montgomerys' right to receive responses to their FOIA requests that comply with the law. FOIA exemptions are to be narrowly construed, yet with respect to requests 1 through 5 in Exemption 7D, the district court held that the IRS must assert GLOMAR in all situations where an informant is involved. The district court made clear this was required even in a first-party request, even if the identity of an informant is not actually at risk, even though the non-existence of records does not implicate a harm cognizable under Exemption 7D, and even if there are in fact no responsive records. FOIA mandates broad disclosure, and no exemption supports the wholesale withholding of all information from a first-party requester based on speculation that a response may indicate the potential existence of an informant in some other FOIA case. 3 decades of precedent interpreting 7D make this clear. 7D, by its express language, protects only the identity of an informant, and after Landano, the agency must establish assurances were provided to a particular informant, and those assurances must be established publicly in order to enable the requester to challenge the claimed exemption. Following Landano, assurances of confidentiality cannot be assumed. The district court further erred here in allowing the IRS to make its case entirely in secret, in-camera declarations as to both whether an informant in fact exists, and if so, whether there were specific assurances given to that informant. 7D is not available to protect the potential existence of an informant. Congress did provide an exemption that would allow what the IRS seeks here, which is to protect the mere existence of an informant through GLOMAR, and that exemption is C2, which the IRS admits is not applicable here. Benavides established that C2 expressly authorizes GLOMAR, but this exemption, like all FOIA exemptions, is very limited. GLOMAR under C2 is proper only where there is a third-party request that identifies the informant by name or identification number, and the informant's existence has not been previously disclosed. The limitation of C2 for only third-party requests makes sense. Antonelli, a Seventh Circuit case, explained the difference between first and third-party requests. It's about balancing the rights of the requester versus the rights of the informant. In a third-party request where the informant is identified, GLOMAR makes sense because if the agency either admits or denies that informant's existence, redacting the person's name fails to protect whether that person is or is not an informant. In a first-party request, such as the Montgomerys, the identity of an informant can be withheld. If allowed to stand, the district court's opinion has effectively enacted a new FOIA exemption that authorizes any agency to assert GLOMAR whenever a potential informant is involved, even in a first-party request. According to the district court, potential speculative harm is all that the agency needs to allege, and that speculative harm doesn't even have to relate directly to the FOIA request and issue. This violates FOIA, and the district court's opinion should be reversed for this reason alone. The facts of the Montgomery's case further demonstrate the district court's error. The IRS claims in its brief that it has to be able to protect every piece of the jigsaw puzzle that could potentially identify a confidential source. But IRS informants were at issue in Life Extension and Millhouse, and there the IRS not only confirmed the existence of informants and records, but didn't even assert GLOMAR. These 2 cases were cited by the district court, but they're not even mentioned in the IRS's brief. The IRS did assert GLOMAR in Sea Shepherd and made a similar jigsaw puzzle argument there that failed. The IRS brief tries to distinguish that case by saying there were unique circumstances given that the IRS had previously admitted the existence of an informant and responsive records. Basically, because the cat was already out of the bag, a response didn't undercut its jigsaw puzzle argument. But the Montgomery's case is the same as Sea Shepherd, just in reverse. The IRS brief confirms its no informant admission. And the IRS's Ziegler Declaration unequivocally swears at JA 335 that Mr. Ziegler saw, quote, no indication that any responsive records had been located, including to requested items 1 to 5, close quote. If the jigsaw puzzle isn't at risk where the IRS admits there is an informant and responsive records, the jigsaw puzzle likewise can't be at risk where the IRS admits there is neither an informant nor responsive records. Further, because the IRS admits that it previously acknowledged there is no source here, if no source exists, it's impossible for there to be a confidential source as required by 7D, because a confidential source is merely a subset of the broader category of source. Without even the possibility of a confidential source, there is no basis for a GLOMAR response under 7D. A GLOMAR response here can't be proper for this reason as well. And this case is particularly egregious. Requests 1 through 5 seek pre-printed, publicly available IRS forms that are not protected by any FOIA exemption. Mr. and Mrs. Montgomery's names are not protected when the Montgomerys filed the FOIA requests. If the requested IRS forms naming the Montgomerys somehow exist in spite of the IRS's no informant and no document acknowledgements, then at the very least, those must be produced. The IRS also claimed GLOMAR based on exemptions 7E and 3. It made one argument for those exemptions that it also made for 7D, and that is that its very effective whistleblower program will somehow be damaged and tax administration seriously impaired. Yes.
Let me ask, in cases where there is no informant and no records of an informant, do you think that the IRS can issue a GLOMAR response?
I think in a third-party request situation, yes, I think that's what C2 allows for. In a first-party request, I do not think that that's the case. And there has been no first-party FOIA request that we have found under 7D where a GLOMAR response has been allowed for a first-party request.
And by first party, you mean when the
where it only names the Montgomerys. In our instance, the Montgomerys did not name any informant by identification number or by name.
Well, if a conspiracy only has 2 people and one of them is the defendant in a criminal case, if it's the practice of the agency to not issue a GLOMAR response when there's no informant and no records of an informant, then the defendant could always seek a FOIA request seeking documents about an informant and records of an informant. And if the agency says, GLOMAR, thank you, Judge, then the defendant is going to know that there was an informant, and the defendant is going to know who the informant was because there's only one possible informant.
I don't believe that's the case, Your Honor. I think that is based on speculation. No one knows if the informant exists or who it is unless the agency confirms that information. They may
why
think,
under the hypothetical you just heard is it speculative at all? If you've got a circumstance in which there is a limited number of conspirators and they are able to surmise that there is an informant, then they know who the informant is, or at least they can narrow it down.
They can narrow it down.
That's not speculation. understanding of humanity and numbers. That's
Well, they may be able to narrow it down, Your Honor, but
Mhm.
FOIA exemptions are supposed to be narrowly construed, and it protects the identity. And there's no telling how many people that other co-conspirator may have spoken to or divulged information
right.
to.
They're narrowly construed is a nice general rule, but they still have to be construed. And that saying narrowly doesn't answer the question. It just gives you a guide as to how you go at it. But if the hypothetical exists that was posed to you, why do you say that's speculative? Everybody knows that that would be endangering the identity of the informant. That
I see I'm into my rebuttal time. I
Okay.
assume you'd like me to continue answering.
No, that's
Go ahead.
okay. That's okay.
Judge Sentelle, do you want her to answer it?
No, that's okay.
Oh, all right.
Just let it go.
All right, Ms. Boylan, we'll give you a minute or so in reply. Ms. Bringer, good morning.
Good morning, and may it please the court. My name is Nora Bringer, and I represent the Internal Revenue Service in this appeal. In the early 2000s, Thomas and Beth Montgomery actively participated in creating and carrying out the tax shelters that were held to be shams in Beaumont and Southgate, which held invalid more than $1 billion in sham losses. That background to this FOIA dispute shows the stakes can be high for tax violations. And when people contact the IRS to share information about potential tax violations, the IRS has a responsibility and a duty to protect them. The IRS, like other federal law enforcement agencies, has a strong interest expressed in its policies, in Treasury regulations, and in declarations submitted in this case, in protecting whistleblowers' confidentiality and in protecting the continued voluntary flow of information to the IRS, which are exactly the kinds of concerns that prompted Congress to expand Exemption 7D's protection in 1986. The Montgomerys raise a number of issues in their appeal, and I'd like to begin with the Glomar issue. As an initial matter, there's no procedural bar to the Glomar response. The court findings and the IRS testimony in Beaumont and Southgate do not preclude the Glomar assertion here through collateral estoppel, judicial estoppel, or the official acknowledgement doctrine. The core problem with each of these arguments is that this case doesn't concern the same issue as anything considered or decided in Beaumont or Southgate. Here, Thomas and Beth Montgomery want to know if the IRS has any of 5 whistleblower forms for certain years that reference them regarding any tax issue, not just what was at issue in Beaumont or Southgate. The district court observed correctly that the existence of records and the existence of an informant in those earlier cases simply aren't the same thing. The Montgomerys also contend that a mistaken reference in an IRS letter during the administrative processing of the Montgomerys' FOIA request was an official acknowledgement, but that letter does not meet the requirements for official acknowledgement with this, which this court has said are strictly applied. That letter specifically did not pinpoint any agency record that both matched the plaintiff's request and has been publicly and officially acknowledged by the agency. In the Wolf versus CIA in 2007, this court held that Glomar was waived only for specific records that were identified in the congressional testimony at issue here. In this case, no specific records were identified, and accordingly, that letter does not overcome the IRS's Glomar assertion here. The district court correctly upheld the Glomar response on the merits. The same standards apply in Glomar cases as in other FOIA cases. The same general exemption review standards apply to a Glomar assertion as would apply to withholding any records themselves. And it's the same test that ultimately an agency's justification for invoking a FOIA exemption is sufficient if it appears logical or plausible. Now, Exemption 7D does not just protect the identity of a confidential informant. It protects information that could reasonably be expected to disclose the identity of a confidential source. And in enacting Exemption 7D, this court said in the Parker case that Congress sought to provide a broad exemption for law enforcement under the Act, under FOIA. Now, Congress adopted the language in Exemption 7D explicitly from the protection that the National Security Act of 1947 affords to national security sources. And the accompanying Senate report to that expansion of Exemption 7D recognized that a confidential source's identity can be compromised when these small pieces of information are released and pieced together with other previously released knowledge and the requester's own personal knowledge. The confidential source exemption under 7D does not require complete and permanent secrecy. The Supreme Court rejected this argument in the Londano case. The court explained that it can't have been Congress's intent that a source would be considered confidential for Exemption 7D only if their identity would be disclosed to no one. There certainly are cases where the identity of a confidential source is disclosed, but that has not been the case here. Here, the Internal Revenue Service has not disclosed the existence or non-existence of any records that are at issue in items 1 through 5. The district court, in describing its reasoning for upholding the Glomar response, echoed this court's discussion of the protection of return information in the tax context in the Church of Scientology case, this court's en banc decision in 1986. In that case, in the Church of Scientology case, this court explained that an agency assessment of the risk of disclosure, and this is a quote, is always problematic because the agency doesn't know what other information the requester has. In this case, the Montgomerys specifically seek whistleblower forms that identify them. They don't simply seek their own records. They seek records of other people who may or may not have talked to the IRS about their tax issues. But the IRS does not know and cannot know with certainty how many people had knowledge of a particular individual's tax issues and whether that list of suspected moles is one person long, a few people long, or much larger. The IRS does not know and cannot know what other efforts have been made to identify a suspected whistleblower, although the facts in this case demonstrate that there are taxpayers who are very motivated in finding out whether anyone has talked to the IRS about them. And that only illustrates the importance of protecting information that could lead to the identification of any confidential informant. And even if one request would not be enough, as has been discussed in a number of FOIA cases, a requester could always submit a series of targeted requests to narrow the pool. So, this request covers 8 years. Perhaps a taxpayer worked with one group of financial advisors in a couple of those years and a different group in another couple of years. A series of targeted requests could narrow down the group even further in trying to identify who may have talked to the IRS about an individual taxpayer. At the end of the day, the district court correctly held that the IRS met its burden to provide a logical and plausible explanation for its Glomar response. And the Montgomerys have not provided any evidence to undermine the IRS's explanation. The district court's decision here is one in a long line of cases that are concerned about that jigsaw puzzle analysis. In the Gardell's case in 1982, this court used a jigsaw puzzle type analysis to uphold a Glomar response with respect to the entirety of the community at UCLA, even though this court recognized that it was an enormous school. And in the Gardell's case, this court was applying FOIA Exemption 3 in conjunction with the National Security Act of 1947. Again, the source for the current standard in Exemption 7D. In that case, this court held that the affidavits were sufficient, that said that the CAA needs and uses intelligence sources in American schools, and that disclosing that such contacts were or were not made at UCLA could be pieced together by people looking to harm the United States. Here, the IRS's affidavits did the same thing. The declaration submitted to the district court explained that the IRS needs and uses whistleblowers and the important information that they share with the agency. And the IRS explained its concern that disclosing the existence of whistleblower records identifying the Montgomerys could be pieced together with other information. Now here the IRS submitted a number of in-camera declarations to the district court. The district court, this court has held again and again, has broad discretion to accept in-camera declarations. This court recognized in Roth and in other cases that receiving in-camera information is necessary to protect the information that the agency is trying to protect from disclosure. In the Londano case, the Supreme Court said that it generally will be possible to establish factors such as the nature of the crime that was investigated and the source's relation to it. But the Supreme Court also said that to the extent that the government's proof may compromise legitimate interests, of course, the government can still attempt to meet its burden with in-camera affidavits. And accepting the in-camera submissions of the government here, the district court acted very well within its discretion. Does the court have any questions for me?
It doesn't look like it. So thank you, counsel.
Thank you very much.
Ms. Boylan, why don't you take 2 minutes or 1 minute? I see 1 minute.
Thank you, Judge Henderson. This case isn't about tax shelters, non-existent sham losses, or quote, snitches, unquote, as the district court and the IRS seem to believe. It's about FOIA's mandated disclosure, except in very limited circumstances that the IRS has not established. Ms. Bringer indicated that there was no acknowledgement, or the acknowledgement of informants was not broad, but it was. That acknowledgement covered any matter relating or involving Tom Montgomery. They were very broad. She also noted Gardles and that UCLA was identified. That's right, it was identified. There has been no extension of GLOMAR to a first-party case like the Montgomerys, where they only name themselves in the FOIA request.
Why does it make any difference if it's a first-party case?
Because, Your Honor, I think the Antonelli court really explained that. They said in a third-party case where you've identified an informant, and again, 7D and 3, the goal is to protect the identity of the informant, not the mere existence of an informant. In a third-party case, the requester has named the informant either by name or a taxpayer or identification number. And in that instance, if the agency were to say they did or did not have records, they have confirmed the identity of that informant or non-informant, but they have done that. In a first-party request, they don't. The FOIA requires they produce as much as possible. And with these pre-printed IRS forms, if they mention the Montgomerys, if they want to redact,
so if they're really wanting to protect, the informant, there is more reason in a first-party case, isn't there?
I don't think so, Your Honor. And then why has there never been a first-party case upholding a GLOMAR response?
All right, thank you.
Thank you, Your Honors.
That's all.
Madam Deputy, would you please call the next case?
Case number 21-1106, Peregrine Oil and Gas 2 LLC petitioner versus Federal Energy Regulatory Commission. Mr. Flume for the petitioner, Mr. Ediger for the respondent, Mr. Echemendi for the respondent intervener.
Mr. Flume, good morning.
Good morning, Your Honor, and good morning, Judges Henderson and Sentelle and Walker. And may it please the court, my name is John Paul Flume, appearing today on behalf of Peregrine Oil and Gas 2 LLC. Peregrine requests this court vacate the FERC's order and remand to FERC with directions that FERC, 1, provide refunds for the illegally assessed charges under the reimbursement agreement, 2, require Texas Eastern to submit the reimbursement agreement to FERC for approval before Texas Eastern is permitted to reassess charges under that reimbursement agreement, and 3, undertake a thorough review of the record that was developed and articulate a reasoned basis for the decisions that FERC will make. Peregrine is requesting that this court give no deference to FERC's decisions because FERC violated the NGA and when it failed to require that the reimbursement agreement be submitted to FERC before the charges could be assessed, and violated the APA by failing to provide a reasoned basis for FERC's determinations considering the whole record and taking into account whatever in the record fairly detracted from the weight of the decision FERC undertook. Now, with respect to the reimbursement agreement, FERC engaged in unreasoned decision-making and violated the NGA when it decided to do nothing about the illegal rate that Texas Eastern assessed under the reimbursement agreement. FERC itself noted that it was unaware of any case law or precedent that would support the finding that a non-recurring charge or a charge that involves a limited number of shippers is exempt from the filing requirements under NGA Section 4C. And yet FERC did nothing about this violation of the NGA. FERC does not have the authority under the NGA to decide not to regulate rates. As the Supreme Court informed us in FPC versus Texaco Inc., Section 16 of the NGA does not authorize the Commission to set at naught an explicit provision of the Act. Section 4C explicitly requires natural gas companies to file with FERC schedules showing all rates and charges for transportation that are subject to the jurisdiction of FERC, together with all contracts which in any manner affect or relate to such rates, charges, classifications, and services. There can be no doubt. Yes, Your Honor.
Flume, let me ask you about the argument that the agreement needed to be filed with FERC. I understand that you think Texas Eastern's responses to the outages were not reasonable and not timely. But for the sake of my question here, assume that I disagree with you about that. How would you be in a better position if the reimbursement agreement had been filed with FERC?
Well, Your Honor, there would have been a record developed as to the justness and reasonableness of the rate that was charged under the reimbursement agreement.
But remember, my question assumes that the response to the outage was just and reasonable.
Well, this is more a question about the charges that were assessed, Your Honor, instead of the response to the outage itself. And so in a FERC proceeding determining the justness and reasonableness of rates, particularly those under the reimbursement agreement, there's a question of prudency of the costs that are incurred, and Peregrine would have had additional rights to challenge the rates that were charged on a justness and reasonableness standard. And the burden would have been on Texas Eastern to prove up the justness and reasonableness of its charges versus the burden being on Peregrine in this instance to prove up the preponderance of the evidence standard.
And now let me give you an assumption that you'll like better than the previous one. Assume I agree with what you just said. Where in your rehearing petition can I find that argument?
On the reimbursement agreement, Your Honor?
Well, not just the reimbursement in general, but the specific argument that you just made to me a moment ago. Where can I find that specific argument in your rehearing petition?
I will need to identify that for Your Honor, and I can certainly take that up on rebuttal if that's okay with you.
That sounds great.
Thank you. So again, with respect to this reimbursement agreement, it is inextricably intertwined with transportation services. There are two provisions in particular that, or two items that I want to raise for Your Honor's attention. Number one, in the reimbursement agreement itself, it states that Texas Eastern has the contractual right to shut in service on the Line 41A system if a party to the contracts fails to pay an invoice, and that can be seen at JA 1038 to 41. In addition, Texas Eastern did not undertake any inspections of or commence repairs of the Line 41A system until after the reimbursement agreement was executed. Thus, there can be no question that the reimbursement agreement itself and the charges that were assessed under that agreement are inextricably intertwined with transportation services. Now, FERC determined in the order that Peregrine failed to demonstrate it was entitled to damages, and therefore it didn't need to address this issue. But that misses a critical point. By failing to file the reimbursement agreement, Texas Eastern assessed an illegal rate. In essence, FERC never determined that that rate was just and reasonable, and therefore Texas Eastern should be required to return those illegally collected amounts to parties to the contract. And Peregrine has a separate agreement with ARENA, who was a party to that contract, and therefore will be entitled to receive a refund of those dollars through that separate agreement that it has with ARENA. Moreover, Section 16 of the NGA provides FERC with the authority to perform any and all acts as FERC may find necessary or appropriate to carry out the provisions of the NGA. Now, a clear application of Section 16 and its authority would be to require Texas Eastern to refund the illegally assessed charges under the reimbursement agreement. In addition, given FERC's legal error to require that the reimbursement agreement be filed for FERC before it could be assessed, refunds are appropriate. Where the Commission commits a legal error, the proper remedy is to put the parties in a position that they would have been in had the error not been made. In the event that Texas Eastern files or had filed the reimbursement agreement with FERC, Peregrine would have had the right to challenge, as we just discussed, Your Honor. And I see that I'm running into my rebuttal time, so I just wanted to raise another point with your honors for a minute or two here on the burden of proof. We do certainly have additional arguments that we've raised before this court, but in the interest of time, we're not going to be able to address all of them in oral argument unless your honors have questions about them. But with respect to the burden of proof, we definitely want to make sure that the court is aware of the portions of our initial brief and the reply brief, the initial brief at 30 to 36 and the reply brief at 9 to 14, where we provided several examples where there was an unequal treatment afforded to Peregrine's record evidence and where greater weight was given to Texas Eastern. Now, unless your honors have any further questions, I just want to conclude that Peregrine requests the court vacate the FERC's order and remand to FERC with the directions as stated, as I stated earlier. Thank you, your honors.
All right, if there are no questions, then Mr. Edgar, we'll hear from you.
Thank you, Judge Henderson, and may it please the court. I'm Scott Edgar for the Federal Energy Regulatory Commission, and thank you for hearing this case today. Judge Walker, I want to go to your questions about the reimbursement agreement, and I want to emphasize that we agree that, while to be sure, Peregrine challenged the abstract question of whether the reimbursement agreement should be filed before the commission, but Peregrine never made the case that it was entitled to damages or some kind of remedy for the failure to file this agreement to which it was not a party. So for that reason, what Peregrine asked for in this case was to be returned to the position that it would have been in, and the commission found that because the Texas Eastern had appropriately responded to both the 2014 outage and the 2016 outage, that Peregrine had not been injured by any action by Texas Eastern. I want to now circle back to where my friend for Peregrine left off with the standard of review. And the commission's position is that the ALJ in this case applied the appropriate standard of review. And as we set out in our brief, the best evidence of the burden of proof. As we set out in our brief, the best evidence of that burden, the ALJ set forth in paragraphs 34 to 35, and this is at JA 940 under the heading of burden of proof. That's point number one, your honors. And number two would be that even if that had been some sort of error, the commission took up this question in its following briefs on exceptions. The commission acknowledged that the word beyond had crept into the ALJ's decision in a couple of places. This is in the affirming order, paragraph 27 at JA 1456 to 57. And the commission concluded that this is not a close case and it's not a close call as to Peregrine's theory of the case and the credibility of the witnesses. And I would also add that the remedy, and Peregrine hasn't demonstrated that the remedy for the use of the word beyond can't be de novo review. The commission had determined in two hearing orders, these are at JA 72 and JA 139, that a hearing was necessary to resolve the issues that were raised in this case. I also want to mention the standard of review for this court. We set that out arbitrary and capricious in the brief. I want to add that, emphasize again that this is a case where the ALJ heard 7 days of live testimony. And this is key to resolution of the factual issues. And the ALJ, therefore, was able to determine the credibility of the witnesses. The ALJ here, she did not find that the witnesses for Peregrine were credible. In this court, in just an opinion issued this month in an NLRB case, the Wind Corporation versus NLRB, issued on March 1st of this month, explained that this court, in the context of the NLRB, accepts the credibility determinations as adopted by the board unless patently unsupportable. And Peregrine has done nothing to demonstrate that the ALJ's credibility determinations are unsupportable. And in particular, I would like to point the court to the ALJ's description of the lack of credibility. This is in footnote 71 of the Timothy for Peregrine as an expert and as a fact witness lacks subject matter knowledge. And in paragraph 117 of the initial decision, where the ALJ explained that Mr. Timothy had acted like an armchair quarterback and displayed a casual disregard for the emergency procedures and the regulatory approval that was necessary for responding to the outages. I want to make a couple of points about each of the outages at issue here, beginning with the 2014 outage. And I think what I want to emphasize is that the decision to close the midline valve was very complicated and difficult for two reasons. And the first reason is that an investigation needed to be conducted close to the platform itself to determine what the proper course going forward would be. One of the solutions could have been to fix the damage there had it not been so severe. And that took time to figure out that that was not a case. That was not the case, and therefore Texas Eastern needed to move on to an alternative, and that meant locating and repairing the midline valve. And if I can make just a couple comments about the midline valve, that wasn't a simple, it wasn't as simple as turning a wheel. It involved removing facilities and adding facilities. And that took time, and it took time in addition for regulatory approval. And again, something that the witnesses for Peregrine seem to ignore. As for the second,
Mr. Edgar, let me ask a reimbursement agreement question. This is related to the question that I asked Mr. Flume. If it had been filed and if there had been a Section 4 proceeding, and if Peregrine had said, hey, these charges that are described in the reimbursement agreement, Texas Eastern ought not be allowed to recover them. Is there a chance that FERC would have said, you're right? Or did FERC's decision in this case answer the question of whether Peregrine's right?
I think the latter, Your Honor. It's the commission determined that irrespective of the filing of the agreement, there was no demonstration of damages. I think what Your Honor is suggesting would be far-fetched. Peregrine would be disputing, we're assuming here that the agreement had been filed and Peregrine is going to challenge that agreement. They're not a party to that agreement, and presumably the parties to the agreement, Arena, Renaissance, and Gomex, wouldn't have challenged it either. Indeed, we don't see their involvement in this case. And not only that, but Peregrine couldn't get any of these producers to serve as witnesses in this case.
So you're kind of saying that there's no way FERC would have said that the cost was unreasonable because everyone who signed up to pay the costs seems to be fine with it.
I think that's the likely outcome.
And did FERC say something like that in its decisions in this case?
No, here what the commission said in, I believe it is paragraph 77, 1473. Here, the reasoning was that Peregrine had not demonstrated that it was entitled to damages for the failure to file. And as we set forth in our brief, that raises two problems for Peregrine. First, related to standing, and in addition to the fact where I started my argument that to be sure, they raised the abstract question of the filing of the reimbursement agreement in the rehearing request, but not the second step of demonstrating that they're actually entitled, as a non-party, that they're entitled to damages here, some remedy here.
All right.
Thank you.
Thank you for your argument, Mr. Etchemendy.
Thank you, Your Honor, and may it please the court. Matthew Etchemendy, counsel for intervener Texas Eastern. So I'd like to start quickly on the reimbursement agreement and the line of questions that Judge Walker had. The commission's holding as the reimbursement agreement was very clear and straightforward. Peregrine simply didn't show that it was damaged by the non-filing of that agreement, separate and apart from the reasonableness of the outages. Now, there are two problems for Peregrine in trying to get out of that on appeal. One is procedural forfeiture. The court has emphasized in many, many cases that there is a requirement to raise issues with specificity in a rehearing request. So you will look through Peregrine's rehearing request. You will not find a place where Peregrine comes out and says, yes, even if Texas Eastern's responses to the outages were reasonable, we're still entitled to damages just on the issue of the reimbursement agreement, and here's why. Peregrine never did that. Now, Peregrine also has sort of late in the game, and in its reply brief, it's raised this argument of, well, maybe we would have been better off because we could have filed a complaint in a Section 4 proceeding. You also will not find that in its rehearing request. So these issues are completely procedurally forfeited. Frankly, also, the argument is extremely implausible on the merits, and I know that Judge Walker, you went over this a little bit, but it is extremely speculative, the idea that in this case, where you had all of the parties to the agreement agree to it, fine with it, never objected, that Peregrine would actually succeed in challenging the justness and reasonableness of this agreement. Whether or not that's a possibility, it's certainly something that Peregrine did not demonstrate, and it was its burden to demonstrate damages. It did not do that. Thank you, Your Honors.
All right, Mr. Flume, why don't you take 2 minutes?
Thank you, Your Honor. Judge Walker, in response to your question, we did raise the issue of damages related to the reimbursement agreement in our rehearing request, in particular at sites JA 1549 to 1550, and actually into 1551. We referenced the reimbursement agreement and FERC's failure to demonstrate or to address the damages question. Further, in our rehearing request, we did mention the agreement that Peregrine had with ARENA, where Peregrine was responsible for 25% of the costs that ARENA bore under the reimbursement agreement. Now, I wanted to address quickly just some points on whether it's speculative.
I know your time's short, so let me ask my question so you have time to answer it and also hit what you're about to hit. And you had a separate agreement to pay ARENA's costs. Why does that not take away causation for standing purposes here?
Well, certainly, Your Honor, but the causation is, admittedly, it's a bit indirect in terms of the actual causation, but if we trace down the causation of the damages that Peregrine faced here, the damages are a result of the delay and of the reimbursement agreement not being filed with FERC. That's the causation that flows through in the first prong of Lujan. We do obviously have a harm, and the redressability is FERC could have addressed this, number one, by submitting the agreement, requiring that the agreement be submitted to FERC, and number two, allowing for that process to go forward. I want to also emphasize to this court that regardless of whether Peregrine has damages that flow from the reimbursement agreement, FERC has an obligation to require that it be filed. And it would set a horrible precedent for FERC to blithely ignore an agreement that was not filed, that is inextricably intertwined with transportation, and allow for pipelines to go forward and not submit these agreements that are subject to negotiations outside of the FERC purview. FERC has an obligation under the Gas Act to ensure that those rates are filed with the FERC. I see I have just a few seconds left here, if I could, on a couple of points on the judge's credibility, if your honors will allow this to go forward. The credibility determinations of the witnesses. I wanted to emphasize a couple points that we had in our briefing for your honors, just to point out the inconsistency in the treatment of witness testimony, particularly with respect to Number one, the obligation, and this goes to the actually, Mr. Edgar, I think it was a cavalier armchair quarterback is how the ALJ referred to the Peregrine's witness, Timothy. His cavalier disregard for the regulations it's interesting in the joint appendix at 962 in the initial decision, the judge pointed out that the application for the permit from the Bureau of Safety and Environmental Enforcement was filed on January 21st, and the application was approved on January 27th, and yet Texas Eastern sent out a boat to repair the pipeline on January 16th, several days before it even filed the application. So while Mr. Timothy was declared to be a cavalier armchair quarterback and casually disregarding regulations, Texas Eastern undertook the exact same action that Mr. Timothy had said was appropriate to do. So instead of giving equal weight to the witnesses, Mr. Timothy was declared to be not given an equal weight for his testimony. And with that, Your Honors, if you have any more questions, I'm happy to answer them, but I think I'll conclude.
All right. Thank you, gentlemen. And Madam Clerk, if you would please adjourn.
This honorable court is now adjourned until Thursday, March 24th at 9:30 a.m.